Housing and Consumer Protection. Fair and equitable treatment in housing and real estate transactions is a right under law. The United States Congress, the U.S. Supreme Court, states, counties, and municipalities have made it clear that everyone needs to have equal access to housing. This mandate is not an option. Real estate licensees must know what classes are protected and what conduct violates anti-discrimination laws to avoid potential liability. In this review, we will examine various federal laws that address civil rights, particularly as they pertain to housing. We'll look at problems that can occur from fair housing violations and your duties and responsibilities to treat all of your clients and consumers fairly and equally under the law. Since we are on the topic of fairness, we'll also discuss federal laws that protect the rights and privacy of consumers. The Civil Rights Act of 1866 prohibited racial discrimination in all property transactions in the United States for native-born Americans, including real or personal property, residential or commercial property, and improved property or unimproved land. There are no exceptions to the Civil Rights Act of 1866. Over the years, court decisions and legislation have upheld and extended laws against discrimination. In 1968, the constitutionality of the 1866 Civil Rights Act was upheld in the landmark Supreme Court decision of Jones v. Alfred H. Mayer Company. The ruling reiterated that the 1866 Act prohibited racial discrimination by the state and by any private organization. The federal government passed a series of acts that extended the Civil Rights Act of 1866 and identified additional protected classes. The 1968 Fair Housing Act was the first meaningful legislation to address discrimination in the sale and rental of housing. It upheld prohibitions against racial discrimination and added religion and national origin as protected classes. The 1974 Housing and Community Development Act reinforced the Federal Fair Housing Act by adding sex or gender to the list of protected classes. Finally, the 1988 Fair Housing Amendments Act prohibited discrimination based on disability or familial status, while greatly expanding the enforcement role of the Department of Housing and Urban Development. So let's quickly review. The Federal Fair Housing Act and its amendments prohibit discrimination in housing based on race, color, religion, sex, national origin, disability or handicap, and familial status. Familial status refers to households that include individuals under the age of 18 who live with either a parent or legal custodian, pregnant women, or any person in the process of obtaining legal custody of a child under the age of 18. There are some exemptions to the familial status provisions. Housing for older persons that is provided under a state or federal program designed to assist the elderly is exempt. Housing that is intended for and solely occupied by persons 62 or older, or housing that is designed for older persons where at least 80% of the units are occupied by at least one person 55 or older, is also exempt. These senior housing facilities and communities can lawfully refuse to sell or rent dwellings to families with minor children or may impose different terms and conditions of residency. A disability is defined as a physical or mental impairment that substantially limits or curtails one or more major life activities. Under provisions of the Federal Fair Housing Act, a housing provider must allow a tenant with a disability to make reasonable modifications to a dwelling or common use areas at the tenant's expense that would permit them to fully use the housing. Where reasonable, the housing provider can require the tenant to restore the property to its original condition upon moving. Landlords must also make reasonable accommodations in rules, policies, practices, or services, if necessary, for the disabled person to use the housing on an equal basis with non-disabled persons. For example, a landlord is required to allow a certified service animal in a building with a no pets policy. Note that the Fair Housing Act also includes wheelchair accessibility requirements for apartment complexes built since 1991. However, apartments on the second floor or above in multi-story buildings do not have to be wheelchair accessible if there is no elevator in the building. There are 4 exceptions to the Federal Fair Housing Act. The Act does not apply to a single-family home sold or rented by a private owner if the owner owns no more than 3 such homes at one time, no discriminatory advertising is used, and no real estate broker is involved. The Federal Fair Housing Act does not apply to the rental of a room or unit in a dwelling with no more than 4 independent units if the owner occupies one unit as a residence. No discriminatory advertising is used, and no real estate broker is involved. Other exemptions apply to religious organizations or private clubs that limit residential units or give preference to their members, but only if membership is not restricted based on race, color, or national origin. The Comprehensive Americans with Disabilities Act, or ADA, was signed into law in 1990. Title III of the ADA prohibits discrimination against people with disabilities with regards to the full and equal enjoyment of the goods, services, facilities, or accommodations, requiring public and commercial facilities to be accessible. Now that we know who is protected under federal fair housing laws, let's review specific activities that are prohibited if they are based on a person's race, color, religion, sex, national origin, disability or handicap, or familial status. It is against the law to refuse to rent or sell residential property after receiving a good faith offer. It is also illegal to use discriminatory advertising or any other notice that indicates a limitation, preference, or intent to discriminate. There are 3 specific prohibited activities that you need to remember: steering, blockbusting, and redlining. Steering is the illegal channeling of prospective buyers or renters to or away from specific neighborhoods based on their race, religion, national origin, or other protected class. Real estate licensees should never make assumptions about the types of neighborhoods where someone would like to live, nor should they limit available properties to only those neighborhoods instead of showing all housing options available. Note that steering is prohibited even if requested by the prospective buyer or tenant. Licensees should ask clients to describe an area where they want to live based on its geographic location or amenities, not based on the people who live there. Blockbusting is also illegal. Before the Federal Fair Housing Act, unscrupulous real estate licensees intimidated homeowners into selling their homes by suggesting the ethnic or racial composition of their neighborhood was changing. Homeowners were led to believe their property values would decline, the area would experience higher crime rates, and the quality of schools would suffer. Through certain techniques, a licensee would induce property owners to list properties for sale or to sell properties at the reduced price, and then turn around and sell the properties at a higher value. Redlining is the illegal refusal to make loans or issue insurance policies on property located in a particular neighborhood for discriminatory reasons, such as the racial makeup of its residents. In the past, many lenders assumed an integrated or predominantly minority neighborhood was a place where property values were declining. Based on that assumption, they refused to make loans there. Since it was almost impossible to get purchase or renovation loans, it was extremely difficult to market, maintain, or improve homes in those neighborhoods, causing values to decline. As mentioned, the Federal Fair Housing Act restricts the publication of any real estate advertising that indicates a limitation, preference, or intent to discriminate based on race or other protected class. In advertising real estate, certain catchwords or phrases that describe a community should be carefully considered to ensure that they do not imply exclusion or a preference for any particular group. HUD guidelines indicate that licensees should use words that simply describe the neighborhood, not the people who live there. An advertisement that includes photographs of human models should strive to include people who are identifiable as reasonably representing all groups in the target area. HUD guidelines indicate ads should portray persons in an equal social setting and indicate to the general public that the housing, product, or service is open to all and is not for the exclusive use of one such group. Remember that all real estate licensees have a legal responsibility to ensure that advertising is truthful and not deceptive. No matter where an ad appears, in print, broadcast, signage, or on the internet, the same truth in advertising standard applies. All advertising of residential property for sale or rent and for financing should contain an equal housing opportunity logo, statement, or slogan as a means of educating the public that the property is available to everyone. The Fair Housing Act also requires that a fair housing poster be displayed and maintained at any place of business where housing is offered for sale or rent. It should be prominently displayed to be readily apparent to all persons seeking housing accommodations or seeking to engage in in residential real estate transactions or brokerage services. Any person or entity can file a complaint through HUD's Office of Fair Housing and Equal Opportunity within 1 year after the alleged discrimination. If HUD determines it has jurisdiction over the complaint, it will investigate. An individual can file a civil lawsuit in federal district court within 2 years of the alleged discriminatory incident. Now, let's change our focus and look at some federal laws that address business practices. Antitrust is a business activity that attempts to monopolize or conspire in a way that negatively impacts another's ability to do business. Believing that fair competition was necessary for the economic health of the country, the federal government passed numerous laws to address intimidation, economic threats, and other unsavory business practices. The earliest antitrust law was the Sherman Antitrust Act of 1890. The activities prohibited by this and later laws are enforced by the U.S. Department of Justice. Certain activities are presumed to be an unreasonable restraint on trade regardless of intent. These include price fixing, group boycotting, allocating customers or market territories, and tie-in agreements. The antitrust prohibition on price fixing refers to two or more competing real estate firms who discuss or agree on the commission rate that each will charge. Licensees must never discuss with or reveal to competitors their intentions concerning fees or other competitive business activities in any way that would imply or encourage the adoption of a standard commission rate. To do so could be viewed as an invitation to conspire with competing firms. This does not mean that a broker is prohibited from telling another broker what their commission split is on a cooperative transaction, however. The typical group boycott allegation in the real estate brokerage business involves a claim that two or more real estate firms have agreed to refuse to cooperate or to cooperate on less favorable terms with a third party. Often the target of the alleged boycott is a broker that employs a discount, alternative, or other non-traditional compensation arrangement. A tie-in agreement results when someone tries to make one transaction or agreement contingent on a second transaction or agreement. For example, a listing contract between a seller and a broker that requires the seller to use the broker's title services. Market allocation is an antitrust violation where licensees from different brokerage firms divide prospective clients and customers in some way, such as property type, geographic area, or property value. Even if the agreement seems logical, these actions could result in a restraint on trade because it limits the choice of the consumer. Antitrust is a fairly complicated subject and applies to many industries and professions. The nature of real estate practice makes real estate licensees particularly susceptible to antitrust challenges. Licensees vigorously compete to secure property listings to offer for sale, but they also regularly cooperate as subagents, buyer's agents, or broker's agents to identify ready, willing, and able buyers for those listings. This dual tradition of competition and cooperation, which exists in few other professions, presents opportunities for antitrust misconduct, whether intentional or inadvertent. When engaging in real estate, you must never behave in such a way as to limit the consumer's choices. Let's conclude with a quick look at a few federal laws that protect the privacy and personal information of consumers. The National Do Not Call Registry allows consumers to add phone numbers to a Do Not Call list that prohibits calls from commercial marketers. Companies must synchronize their lists with an updated version of the National Registry at least every 31 days. A telemarketer or seller may call a consumer with whom it has an established business relationship, or EBR, for up to 18 months after the consumer's last purchase, delivery, or payment, even if the consumer's number is on the National Do Not Call Registry. The CAN-SPAM Act is intended to curb unsolicited commercial emails and text messages. It gives recipients the right to opt out of receiving emails. Senders must honor opt-out requests within 10 business days. Senders of faxes are required to take reasonable steps to verify that the recipient consented to have a fax number listed if it was obtained from a directory or other source of information compiled by a third party. They must also provide notice and contact information on the fax that allows recipients to opt out of future faxes and must honor such opt-out requests within 30 days. That concludes this review on fair housing and other consumer protection laws. Remember that equal access to housing is a fundamental human right. It is your responsibility to understand fair housing laws, federal, state, and local, and treat everyone fairly and equally. It's one of the most important issues you will face in your real estate practice. Failure to comply with fair housing laws can result in stiff fines, suspensions, or even the loss of your license.
Confidence. Most of the guards at Fort Z don't even know why they're there. Show confidence, and they'll defer to you.
to her hair now because she can't show.